Okay, CR 21-208, State versus Bryce Carol. All right, Mr. Carroll, we, our last meeting ordered you to do a few things. I do find that you are negative on your urinalysis exam today, so that's good. I ordered you to pay $60 to probation. Did you do that? When did you do that? For March. Today is for March. My records don't show that you paid anything. That's why I'm wondering. Well, yeah, you could certainly pay it today, but what about your 300 to your court collections? You haven't paid, why not? You can pay, so you can pay your court costs of 300 and your 60 today? All right. What about your community service? Well, we're looking at March. So how many did you do for March? Over 30? All right, so you need to, if you're not turning those things in, and my report says that either you're not turning them in, or whoever you're supervised where, Dallas County or somewhere? Okay, so either we're not getting those down here in time for me to have my reports updated, so you need to just bring those things, all right? Get you a copy, bring those things with you so we can verify it down here, okay? And then you'll need to see Ms. Burns. I'm gonna reset you for April 30th. And so for this month, we're gonna do the same thing. 60 to probation, 300 to court collections, and we'll do 20 hours community service. Or actually, we'll do 30, I'm sorry, 30. Looked at that wrong. And you'll need to have those things done before you come to court on the 30th, okay? All right, so sign this, come over here and see Ms. Burns, and then you'll walk in across. This is Sanctions Court for State versus Patrick Rowe. Give me just one moment, Mr. Rowe. I got to read your report here. Mr. Rowe, there's two issues I think that have brought you here today in Sanctions Court. First of all, do you understand what Sanctions Court is? Do you? In your own words, what is it? And well, that could be a motion to revoke, but there's a bigger purpose. You know what the spirit of Sanctions Court is? Sanctions Court is basically an intervention program where we see people who are either not taking their conditions of community supervision seriously, and we're trying to prevent them from having a motion to revoke filed and a possible prison sentence. You understand that? So two issues. One, it appears that the probation department was trying to get you in compliance with your phone and internet devices, and they had to stay on you to get it done. And they said you finally got it done yesterday, but they've been on you for quite a while to do it. And you haven't worked any community service since December. And you pled out in December to online solicitation of a minor, right? I know.
6 hour day, or I was, didn't know that. I need to report to tomorrow.
Well, no, you report to who you report to, and you do your community service, and then they transfer or transmit all of that data to us. But my report said that we don't have any of that information. But you're saying that you did work, you've worked how many? 6 10-hour days, so you've worked 60. And where are you doing your community service at? And that's one of the approved locations for community service by the Smith County Probation Department? Okay.
Or all this, place how would I work if they are approved, it's not on their list.
But they've approved it. Okay. All right, so what I'm gonna do is I'm gonna have you come back on April 30th. And I need 10 hours of community service. And what I'll do is I'm gonna have my probation department reach out to Smith County to find out why we don't have that information and to verify it. And to just admonish you that if you don't want to be coming back on Sanctions Court and having to come here and be questioned about your decisions, then you need to be in strict compliance So if the probation department tells you, you gotta do X, you do X. You don't do X at the last minute when they tell you, okay, we're just gonna send you to court and you're gonna go explain it to the judge and then you comply. If that's the way it's gonna work, then you're not gonna be a good candidate for probation. We'll just revoke you and you're looking at 2 to 10, 2 to 10 in prison. Understand?
I learned this, also with home issue, was that as long as I wasn't on possession of the device, I just wouldn't have one. I wasn't using, and then they had a problem getting the whole thing. It's my fault. I'm trying to say it's not my fault, but it's a misunderstanding on my part.
Okay, good. Well, make sure your probation officer understands that. Go in there, own it like a man, take responsibility, take accountability, and tell them that you're gonna be a model probationer from here on out and get them on your side. Okay? All right. So 10 hours community service. We'll come back on the 30th. We need to verify Rachel his 60 hours with Smith County. No, I think he's okay on his fees. That's all that I have. Was the phone issue and community service. Come over here and talk with the probation officers and we'll get that cleared up. And because yeah, you will need to pay those here unless Mr. McSpadden, this is cause number CR 22-36, State versus Guy Ezekiel McSpadden on the state's motion to adjudicate. Court finds that Mr. McSpadden is indigent, has requested court-appointed counsel. The court has appointed the Honorable Jonathan Manning. And Mr. Manning, this is, I believe, your first appearance. I'm assuming that you will want to reset, or is there another announcement?
Yes, and like we said, I believe we are close to a conclusion. I've spoken to the state and probation department. I believe we'll be able to resolve this. We could set it for the 30th, April 30th.
All right, court will set Mr. McSpadden then for April 30th at 9 a.m.
Thank you.
Mr. Schmidt, do you by chance have that cause number with you?
Yes, sir. It's CR 25-0015.
All right, this is State versus Christopher Blevins, cause number CR 25-00154. Go ahead, Mr. Schmidt.
On Tuesday, spoke with the state after Tuesday's issues. I think we're still sitting down. We're gonna identify county one and the time of that warrant, but we could be setting this to 11 to complete.
All right, court will set Mr. Blevins then for plea April 28th. Will that be a 9 o'clock plea or 9 o'clock? With discovery or subpoenaed records, what's the update?
Out. Got out that day, or right within that time. The issue that we're starting to have is we are getting responses from providers that we know existed, and the providers are saying, didn't they exist? Like they said, like, not only did they not have any records, but that like she was never at that facility, and she actually was, like, her child was born there. We know. So there's clearly some sort of internal issue. I have a meeting set with their hospital legal counsel to try and see if we can figure out where the disconnect is. It may be something as simple as a name, like a maiden name versus a married name issue. But it's very hard to like figure that out when they can't release any further information outside of exactly the scope of what we've asked for. So we have tried to broaden that scope so that we are getting the widest net cast. But like I said, I also have a meeting set with their counsel to try to figure out.
When is that meeting?
Sorry?
When is that meeting?
It's in 2 weeks. On the 17th.
April 17th?
Yes, sir.
All right. State, any objection to the court extending another docket call?
Your Honor, at this point, state would object. The offer that's been made is pending, and our understanding that no matter what the results of subpoenas are, that offer will be rejected. State would ask that this be over to the trial about that.
Any response, Ms. Harrison?
Yeah, sure. And if we can, so the allegation in this case is filing falsified records. I think once we get the records and can just demonstrate to the state that they were never falsely filed and they do exist and have existed this whole time, that may resolve the case. It's really kind of the crux of the entire thing.
Your Honor, and if those records were, produced, that could certainly be dispositive. At this point, though, Your Honor, we've been, the case was filed a little over a year ago. We're on our ninth setting, it's been about 2 months apart. So I think, by setting it on the trial docket, Your Honor, I don't think it stops subpoenas from going out and resulting, return. So that's what the very well will end up being dispositive, but at this point, I think just going ahead and moving along so that we're not dragging this out indefinitely.
All right, so what I'll do, Ms. Harrison, is I'll go ahead and place Ms. Kaiser on the jury selection docket for May 4th. And obviously, if there's something that is dispositive and the state files a motion to dismiss, the court will grant that. If there's any hearing that needs to be had regarding some type of evidentiary issue, then just notify the court and we can set that on the docket. But we'll go ahead and place her on the jury trial docket, and that, and if things develop, that's fine. You just notify the court. If they don't develop, then she'll go ahead and have replacement on there. That is the rolling docket. Yes, ma'am. Yeah, so she wouldn't be reached that day. Okay.
Thank you.
All right, and once Ms. Kaiser signs her notice of appearance, she is free to go.
Thank you.
You're welcome. Oh, and Ms. Kaiser, so on May 4th, you will not report to the courtroom. We'll be picking a jury that day on another case. I'm confident. So you won't report up here. However, my staff will be downstairs when you do report to the courthouse, and they'll have a notice of appearance for you to sign. You can meet with a pretrial release officer, and Ms. Harrison's not going to be required to be here because it's not going to be an official court hearing. So you're just going to check in with my staff, receive your reset date. Once your case is likely to be set for trial, I'll notify Ms. Harrison and she'll know to be here. If you'll, can you continue to come at like 9:45 like you've been doing it? Does that still work in a break there? Okay. All right, then yeah, we'll just do that May 4th at 9:45. Okay.